Hello, and welcome to the Winchester Law presentation on basic estate planning tools. My name is Attorney Chris Winchester. Today, we will be discussing powers of attorney, what they are, the various types of powers of attorney that are available, and how having well-drafted powers of attorney can help protect you and your family from unseen events. A power of attorney is a document granting a third party, called an agent, the power to act on your behalf in specified matters. This power can be useful to ensure that your end-of-life wishes are honored, that your property is carefully managed in the event you become disabled or incompetent, and also help create continuity for the rest of your estate plan if you are unable to act yourself. In Wisconsin, powers of attorney are divided into two types. The first type are financial powers of attorney, which give your agent the power to act over your property. Under this type of power, your agent might have the power to do things such as manage your bank accounts or make payments on your behalf if you were unable to do so yourself. The second type of power of attorney is the healthcare power of attorney. Just like the name implies, this type of power gives your agent the authority to make healthcare decisions for you if you cannot do so yourself. This might include the power to authorize or withhold treatment, or the power to discharge you into a nursing home or home care. Although there is no requirement to have both a financial power of attorney and a healthcare power of attorney, a well-thought-out estate plan generally includes both types to ensure that someone is able to act for you in every eventuality. In addition to the types of powers already discussed, each type can be further subdivided into springing and non-springing powers of attorney. These designations determine when a power of attorney will take effect. Under a springing power of attorney, the power only becomes active, and your agent therefore able to act, upon the occurrence of a specified event, typically your incapacity. By contrast, under a non-springing power of attorney, your agent may begin acting for you as soon as you execute the power of attorney document. Under Wisconsin law, powers of attorney will be considered non-springing unless you specify otherwise. Regardless of whether a power of attorney is springing or non-springing, it is important to note that your wishes will always override those of your agent, as long as you are competent to make your own decisions and able to communicate your wishes. Many clients are initially uncomfortable with the idea of a non-springing power of attorney, as they have concerns that their agent will act against their wishes. However, most estate planners will recommend that clients make their powers non-springing for two reasons. First, the chance of an agent quote-unquote going rogue can be reduced by naming someone you trust to that position. Secondly, springing powers often run into practical problems when the time comes to actually implement them, because there needs to be documentation that the event triggering the power has in fact taken place. For example, if a power triggers only on your incapacity, there will typically need to be physician documentation that you are in fact incapacitated. Since this documentation can take time to secure, springing powers run the risk of leaving your agent unable to act for you when you need them the most. This concludes the presentation on powers of attorney as a basic estate planning tool. I hope you found it useful and informative. If you have any questions about powers of attorney, or estate planning in general, please do not hesitate to contact us at the phone number or email address provided below. Again, I would like to thank you for watching, and I hope you have a wonderful day.